Hearing in the appeals ABC against principal report of another and in the matter of XY.
Yes.
My ladies and my lords, the cases of ABC and XY are to be heard together, so I intend to introduce everybody in the order in which we're going to speak. I appear for the appellant ABC together with my learned junior, Mr. McAlpine. Mrs. Scott QC appears for the appellant XY with her learned junior, Mr. Aitken. Ms. Coots appears for MM and SM. They are the fourth respondents in the case of XY. They are the parents of XY and his siblings. Mr. Richardson QC appears for AM, the fifth respondent in the case of XY, together with his junior, Miss Gilchrist. Mr. Moynihan, who's hiding behind
He's
me.
hiding behind you. I can't see him.
He's lurking.
QC appears for the principal reporter, the first respondent in both cases, together with his learned junior, Mr. Guy. Ms. Dunlop, who's over here, QC appears for the Lord Advocate, the second respondent in both cases, with her learned junior, Miss Charteris. Mr. Mitchell appears for LM, the third respondent in the case of XY, together with his junior, Miss McKinley. And finally, Mr. Setwright appears for the safeguarder in XY, the sixth respondent, together with his junior, Mr. Powell. Finally, in addition to all the parties that your ladyships and your lordships are going to hear from, there are written cases lodged in ABC by the parents of ABC and DEF, and they are referred to as YL and XL and are interveners.
And I suppose, although I don't think there's any risk of anybody transgressing, I should, for the sake of everybody, remind everybody that the court has ordered that no one shall publish or reveal the names or addresses or schools of the appellants who are the subject of these proceedings, or of any members of their families, or publish or reveal any information, including any picture or photograph which would be likely to lead to the identification of the appellants or of any members of their families in connection with these proceedings.
Yes, my lady, the case of ABC is about two siblings, ABC and DEF. ABC wants to preserve his relationship with his brother, DEF. When the events complained of in this judicial review started, ABC was 13 years old and DEF was 6 years old. They'd lived together with their family, that being their mum and dad and their two older sisters. They were all part of the same core family unit, a mum, a dad, and 4 children. On the 14th of June 2016, ABC and DEF were removed from their family home, and they were accommodated with foster carers. They were not accommodated together. ABC was placed in one foster placement and DEF was placed in another. ABC returned to the care of his parents on the 26th of July 2017, and DEF remains accommodated with foster carers. ABC is now 16 years old and DEF is now 9 years old. DEF is important to ABC. He is his little brother. ABC wants them to preserve their sibling relationship. The sibling relationship can be the most enduring relationship in one's life. Any children who have siblings, whether they're looked after by state intervention or not, should have the opportunity to maintain that sibling relationship. Now, the ABC and DEF came before the children's hearing. They were referred to the children's hearing, and that meant the family was the subject then of state intervention. The family was before the children's hearing as a whole. The children's hearing is a lay tribunal which exists to make decisions in the best interests of children who need protection, guidance, treatment, or control. It has the power to make compulsory supervision orders which can contain a wide range of orders within that compulsory supervision order. The court will find a full explanation of compulsory supervision orders in the note of argument for ABC from paragraph 10, which is at MS 0076 on the ABC pen drive. I should refer at this stage perhaps to the court. There are two, because there are two cases and the appendices are confidential to each, we have some numbering issues, I think, in relation to the note of authority, the list of authorities. The printed pages run from page 1. For the avoidance of doubt, where I make reference, I'm making reference to the memory stick in ABC, because I don't have the one in XY, so I make reference to that. There is, I think, before the court a table which perhaps shows where each case is in each of the pen drives, and Malhernon Jr. has further developed that table if it becomes necessary for the court to have it. In this case of significance, the children's hearing has the power to make orders regulating where a child is to reside and orders regulating the contact that the child has with any person. Compulsory supervision orders can last for a maximum of 1 year. On review, they can be continued again for a maximum of 1 year. And a child can be the subject of a compulsory supervision order until he or she attains the age of 18. Following a multitude of European jurisprudence, the children's hearing, by separating children from their parents, exists to attempt to reunify the family as soon as is possible. The children's hearing has no power, however, to terminate the legal relationship between a child and a parent where reunification is impossible. As I say, the orders it makes can last for a maximum of 1 year. From 2016, ABC and DEF and the whole family were before the children's hearing. Both brothers were the subject of compulsory supervision orders. Both of their orders included orders regulating where they were to reside, i.e. with foster carers, and orders regulating their contact with their parents, but also orders regulating their contact with each other and their older siblings. Those were orders which impacted on their relationship as siblings. They were no longer living together in family. Their contact with each other as brothers was no longer unfettered. It was all regulated by the children's hearing. The court will have seen in the notes of argument that there is reference to the United Nations Convention on the Rights of the Child. The Convention applied and applies equally to both ABC and DEF. They are both children as defined in the Convention, that being that they're under 18. Article 12 of the Convention applies equally to ABC as it does to DEF. The text of the whole Convention is produced in the Safeguarders Bundle at MS 0471 in that bundle. But the court will be familiar with Article 12 that states parties shall assure to the child who's capable of forming his or her own views the right to express those views freely in all matters affecting the child. The views of the child being given due weight in accordance with the age and maturity of the child. And the second part of Article 12, for this purpose, the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative or an appropriate body, and in a manner consistent with the procedural rules of national law. Now, up until ABC's compulsory supervision order was terminated in November 2017, both ABC and DEF were the subject of compulsory supervision orders, which affected them as individuals and also affected each other by affecting their relationship. ABC returned home on the 26th of July 2017. As I say, his compulsory supervision order was terminated on the 7th of November 2017. From that later date, he was no longer as an individual child before the children's hearing. But the family remained before the children's hearing because DEF was still subject to the compulsory supervision order. In his compulsory supervision order, there had been and continued to be made orders which affected ABC, because there continued to be orders which regulated DEF's contact with his brother. And the judicial review in ABC relates to two decisions in particular. The decision of the children's hearing on the 7th of September of 2017. The court will find that at MS 0417.
Can you very kindly give us bundle references? Unfortunately, it hasn't been loaded on my machine.
I apologise, Malese. I can give you a paper reference for that. It's page, it is MS 0417. It's in the
Isn't it the first page of core volume 2 of 2?
I'm very grateful.
I think it's 257 is the
It is, yes.
page number.
I'm very grateful, my lord.
So much, thank you.
And this has all been redacted?
It has, yes, mighty. There is a redaction key somewhere in the papers as well, if that assists the court. But it has been redacted as it was in the inner house. The inner house, sorry, the outer house at first orders in December 17 granted an order that the children were to be referred to as ABC and DEF in all. So the pleadings are reflective of that, and the productions have been redacted to reflect that. This is the compulsory supervision order which was made following the children's hearing on the 7th of September of 2017. and the court will see that the continued measures within that compulsory supervision order, the first one is for the implementation authority to provide appropriate supervision and support to the child. The second is that the place
Is that
where...
absolutely standard in every order?
It is, yes.
Yes.
The key one for you is paragraph 5.
The key one is paragraph 5, yes, Lord. It's the direction in relation to contact. The second hearing, which is the subject of this judicial review, is the one of the 5th of December, the 5th of December 2017. And the court will find that at MS 0489, and your ladyship will find that at tab 16 in the core bundle 2 of 2. And the variations, it's the first of the variations on that compulsory supervision order, and the second of the variations which relate to contact between the siblings. It is my submission that at both of these children's hearings, ABC was denied a proper opportunity to take part in the decision-making process leading to those orders. And because he was so denied, those decisions, insofar as they relate to contact with ABC, were unlawful. If I can turn to the methods of participation in the decision-making process of a children's hearing, it's a matter of concession in ABC that he and DEF have established family life within the meaning of Article 8. There is the real existence in practice of close personal ties. The procedural protections of Article 8 are engaged, but here we run into the problem of the system. A proper opportunity to take part in the decision-making process of the children's hearing for anyone other than the subject child is only available to those who automatically have or acquire the status of relevant person. The statutory scheme is binary. You're either a relevant person or you're not. It's all or nothing. It is...
That's agreed, is it, that it's all or nothing?
No, it is not agreed. That is what I argue. I think the principal reporter argues that there is a discretionary mechanism within the system, and I'm coming on to address why that is not the case in my submission. All other methods, I say, of participating in the decision-making fall short of what would be required for the procedural protections of Article 8. And it becomes a bright line distinction. If you're a relevant person, then you can properly take part. If you're not, you cannot. I say that the other methods of involvement in the decision-making process that are available are discretionary. They're subject to human failing, which on any view occurred at the two children's hearings that this judicial review relates to.
Well, everything is subject to human failing if it's done by humans. I think this hearing is similarly subject to. human failings.
I'm trying my very best not to make any.
Well, so will we, but it doesn't mean to say that we won't.
Yes. I do say they're inadequate and don't constitute a proper opportunity to take part. And there are certain elements which demonstrate that. It's only a relevant person who is guaranteed notification of a forthcoming children's hearing. The relevant rule being Rule 22 of the procedural rules, which is at MS 0832. Only a relevant person can require a review children's hearing be held if something has changed in relation to the child. They can ask for a children's hearing to be held not less than 3 months after the making, continuing or varying of a CSO. And when I use the expression CSO, I mean compulsory supervision order. It's a shorthand. Only a relevant person is provided with the papers before the children's hearing, on which papers and with the representations at the children's hearing, the decision will be made. Only a relevant person has the right to make representations to the children's hearing. Only a relevant person has the right to attend the children's hearing. And the flip side of that right is their duty to attend, which comes with it, on a failure to attend, a criminal sanction, and I'll return to that. Only a relevant person can have legal representation at the children's hearing. And only a relevant person can review or appeal the decision of the children's hearing. Where, as your ladyship points out, human failing occurs, something goes wrong, it's only a relevant person who can appeal the decision of the children's hearing. There's perhaps a good example of that in the case of V against Locality Reporter. It's at MS 1211. For your ladyship, it's in the second bundle of the joint list of authorities, and it's at tab 15 in that second bundle. This is a decision of a sheriff on appeal from a children's hearing, and it illustrates, perhaps in similar circumstances, under the old statutory regime, under the Children's Scotland Act 1995, how someone in ABC's now shoes could have tried to rectify what happened at the children's hearing of the 7th of September. You'll see, the court will see from the rubric that V, aged 13, and L, aged 7, had lived together with their mother until 17th December 2009. The rubric then narrates that they bounced about between their aunt and uncle and foster care, and ultimately, over the page, V returned to her aunt and uncle while L was looked after by foster carers, but they had contact with each other. In May 2012, the Children's Hearing expressed the expectation that contact would be increased if it benefited V and L. Contact took place for 2 hours a week until June 2012, when it stopped. In July 2012, contact was re-established for 2 hours each fortnight. On the 31st of July 2012, a permanence panel recommended that a permanence order be sought for L. That's an order which is sought from the Sheriff Court and does have the capacity to terminate the relationship between parent and child. In August 2012, contact was reduced to 2 hours each month. It was noted that V's lack of contact with L was distressing V. On the 8th of October 2012, the Children's Hearing reviewed and maintained the decision to reduce contact. V was not invited to attend any hearing, and the Children's Hearing did not consider whether she was a relevant person. V appealed the decision of 8th October 2012. The central issue was whether the appellant was a relevant person and entitled to participate in the Children's Hearing proceedings in respect of her brother, in the light of the decision of this court in Principal Reporter against K. It was argued for V that she had established family life and the hearing had interfered with it by restricting contact. This was particularly pertinent as V was likely to be rehabilitated with her mother shortly, and ongoing contact might be a very important factor in any prospect of rehabilitating L with his mother. The reporter conceded that V had established family life and the hearing had interfered with it, but it was submitted that Principal Reporter against K had involved an unmarried father and a restrictive approach should be taken. Further, a high standard should be met before someone other than a natural father should be treated as a relevant person. The sheriff in that case found V to be a relevant person, and he said that the Children's Hearing failed to consider whether V should be considered a relevant person in L's proceedings, and that alone would have been sufficient to justify upholding the appeal. What V is appealing is the decision that took place without her involvement. And secondly, the sheriff held that the extended definition handed down by the Supreme Court widens who may be considered a relevant person for proceedings before the Children's Hearing. Two questions arose: has the person established family life with the child? And two, may the Children's Hearing interfere with that? Now, what he then finds is, by not considering V as a relevant person, the Children's Hearing had denied themselves material information regarding one of the most important persons in L's life. V was 13 and well able to form and communicate her own views. For younger children who might be relevant persons, consideration would have to be given to dispensing with intimation if they're considered unable to form a view. But in borderline cases, it'd be safer to include than exclude. Now, that was a mechanism open to V under the previous legislation to appeal the decision on the basis that she should have been regarded as a relevant person, given notice of that Children's Hearing, given the paperwork that was provided, a right to attend, a right to make representations, and a right to appeal.
Was that because there wasn't a definition of relevant person which excluded V at that stage?
Indeed, it was because the definition as read down by this court in Principal Reporter against K effectively allowed persons who had family life to argue they should have been a relevant person.
You say the 2011 Act in Section 200 now does block that, or may block that.
Section 200 certainly blocks it in terms, without being read down. Section 81 is the mechanism in the 2011 Act whereby someone can apply.
Yes.
My learned friend, Mrs. Scott, is going to take the court through Section 81 in more detail because, as the court will be aware, ABC did not apply in Section 81 because he does not consider that he falls within the definition in Section 81.
Thank you.
And the previous legislation didn't have that Section 81, if you like, hurdle which you had to get over before you could become a relevant person. Of course, Section 81 only becomes applicable where there is going to be a Children's Hearing. And if you're not told that there's going to be one, it's very difficult to apply to be a relevant person through Section 81. But as I say, my learned friend, Mrs. Scott, is going to concentrate more on Section 81 than I will.
Ms. Bradman, at some stage, are you going to explain, for the benefit of some of us, a little bit more about how a children's hearing works? And in particular, what reports are made to the hearing, by whom, and what inquiries they have made on the ground before making a report, so we can understand, as it were, the possible conduits for the views of siblings to be transmitted. Would it be via the reporter to the hearing and all that sort of thing?
Yes. Well, there is an explanation, and sort of maybe a broad explanation of the children's hearing system in the note of argument, but if I can expand particularly in relation to the reports which might be available.
Thank you.
The children's hearing, the reporter provides administrative and support to the children's hearing, but it's a lay panel of 3. On a child being referred to the children's hearing, the reporter will then ask the relevant parties for information reports to allow the reporter to form a view whether a children's hearing should be held. That report to the reporter, the referral to the reporter, might come from a number of sources, but it principally comes from social work departments of local authorities. The reporter will ask for a report from the social work department, who are the implementation authority of any order. That report provides a great deal of information. It starts off with information about how the child came to the attention of the social work department, usually the child's history, the family history, and then it deals with specific parts of a child's welfare. So, for example, education, if the referral starts off with education, might refer to criminal behaviour if the child has been referred to the reporter as a result of offending behaviour. It might also relate to their need for protection from abuse from a party within their own home or out with. And it will normally give, in fact it has to give, a report on the family circumstances of the child. So that would include their siblings, whether they live with them, whether they live out with the home, etc. In addition to a report from the local authority, from the implementation authority, there might be, before the children's hearing, reports from the child's school. And in addition to that, reports from perhaps the health services, if there are issues in relation to the health of the child. In addition, the rules permit the child themselves and relevant persons to provide a report to the children's hearing. All of that information is then gathered by the reporter, and then if the reporter determines that a children's hearing is to take place, all of that material is provided to the 3 members of the children's hearing and is provided to the child and to all relevant persons. The scope, if I have your Lordship's question, the scope for giving the children's hearing information about a sibling's views is through the social work department report. And a well investigated and well put together social work department report would include perhaps the social work's interviews with the siblings, asking them what they feel about contact. That is not universal in practice, but I absolutely concede that a well put together and well investigated report will contain that.
Would I be right in saying that the norm would be that the social work report would include statements about the fact of contact with siblings, even if it's a particularly good one, you say, that would have interviewed those siblings?
I think it would be, I would normally expect to see that in reports from the social work department. The fact that contact's taking place, I would also normally expect to see the social worker's recommendation as to what should happen in relation to sibling contact.
Thank you.
Well, is there any regulatory provision which requires social workers to contact siblings.
There's no regulatory provision that requires them to do so. There is regulatory provision in the rules for their report to the children's hearing to include the family circumstances of the child, and good practice would dictate that that would include contacting siblings, but there's nothing that requires them to do so.
Is there a guide, such as there is south of the border, in relation to the compiling of family assessments and what's to be done and what they've got to contain?
The requirements of a social background report, which is what it used to be called, and the name of it that they now call it has escaped me, but there are standard requirements of that report in regulation. Mr. Moynihan may be able to help the court with the precise regulation. I haven't got it off the top of my head, but and certainly I can look for it overnight and produce it in the morning, but there is regulation which prescribes the elements of the report which has to be compiled by the implementation authority, and that includes the family circumstances.
Well, I think that would be a helpful document for us to see.
I will ensure that that's produced ready, or certainly the reference, and overnight.
Thank you.
But also if there's any good practice guidance, because it's absolutely standard, at least it was when I was doing care proceedings, and I'm sure the same will be true of my lord, that social workers would compile something called an Orange Book assessment. And the Orange Book was a very long, very fat collection of really saying how you're to go about it and who you're to see and what you're to assess and so on.
There is social work guidance, which was issued by the Scottish Government in relation to the content of what are called GIRFEC reports. That is meaning getting it right for every child.
Ah, yes, yes.
Which is a report which was released, and so GIRFEC guidance was issued by the Scottish Government, and reports, including reports to the children's hearing by a social work department, have to follow the GIRFEC guidelines. And again, I can endeavour to, the GIRFEC guidelines are certainly not before the court in the bundles that we have, and I will endeavour to produce information to that to the court tomorrow morning.
Thank you.
I think the only other aspect that I would be grateful for education about is the representation of the child himself or herself. You've indicated that there's legal representation for him or her. So there's a solicitor. Perhaps there's an advocate. What does the solicitor do in discharge of her duty to represent the child? And does somebody go to the relevant houses and the relevant people on behalf of the child to collect information which will enable the representative to put a balanced picture on behalf of the child before the hearing?
There's a couple of points within that, and I'll perhaps break them down. Because it's a lay tribunal, the children's hearing, there has always been a resistance to making it too legalistic, too formal. So the number of legal representatives of any party who's before the children's hearing is discouraged from growing, mushrooming. So the child is entitled to a legal representative who's there to represent the interests of the child before the children's hearing and to communicate their views to the children's hearing and to the discussion which takes place before the children's hearing. Your Lordship has in mind almost a role akin to guardian in England.
I do.
And in the children's hearing system, there is the ability for the children's hearing to appoint what's called a safeguarder. There's no safeguarder in the case of ABC. There is a safeguarder appointed in XY, and indeed Mr. Setright appears for that safeguarder. The safeguarder's role in the children's hearing is one which is what I think your lordship envisages, in that the safeguarder has the capacity to go and visit the child in their placement, to visit siblings if the issue is sibling contacts, and to make inquiries in relation to the things that appear to the safeguarder themselves to be important to the child's welfare, but would also be able to investigate issues in relation to if the child was particularly concerned about seeing their siblings, then the safeguarder would be able to act on that and investigate that. No safeguarder was appointed in ABC.
What's the criterion for appointing a safeguarder?
The criteria is that it appears to the children's hearing, and I will get the precise statutory definition, but it appears to the children's hearing that it would be appropriate for a safeguarder to be appointed.
And I'm sorry, Ms. Brabender, I really must stop asking you questions and enable you to get on with it. But there's one other aspect to the children's hearing that I don't really understand.
Yes.
Grounds are put forward for the CSO, and it does appear from a particular section that unless all relevant persons consent to the grounds, or one of them, there can't be a CSO. Is that right? And if so, does that hobble the children's hearing?
Yes.
What happens is that grounds are prepared by after initial reports are gathered by the reporter, and if it appears to the reporter that this child is in need of compulsory measures for their protection, their guidance, their treatment or their control, then the reporter compiles grounds of referral. Those grounds of referral are then put to the child and to the relevant persons at a grounds hearing. If the child and the relevant persons all accept the grounds of referral, then it can be determined whether or not another children's hearing should be held and at which a CSO might be made. If the child's too young to understand the grounds, or if any relevant person does not accept the grounds, they deny the grounds, then the reporter requires to go to the sheriff to establish the grounds of referral. And that is normally by proof on those grounds of referral, and the sheriff determines whether or not grounds are established. If the sheriff determines that grounds are established, he or she sends it back to a children's hearing to determine whether a CSO should be made.
Thank you.
It is an important point, Lord, because of course, if ABC was a relevant person, then he too would have to accept or deny the grounds of referral. And that's an onerous task. And it might be a task which a sibling can't perform because they don't know what the circumstances were which led to these grounds of referral. Grounds of referral that might relate to a parent's conduct towards that sibling. And I'll come to that because I think it is an issue in relation to relevant person status.
Yeah. One of the concerns that has been expressed by some people looking at the children's hearing system is that despite its obvious attractions, the fact that if the grounds of referral are disputed, the whole thing has to go off for a formal proof before a sheriff is a disincentive to dispute. And that people will be much more likely to say, oh, all right, I will go along with it, or to try and negotiate with the reporter some amendments to the grounds of referral so that it turns into something that they can accept, rather than have a proof. Is that criticism warranted? I can see Mrs. Scott is nodding her head, but she would do that, wouldn't she? Yes.
I think there's always an argument that might be that might make people more susceptible to simply accepting the grounds because it might move on quicker than it would if there was a proof on the grounds of referral. It can also be a disincentive to accept the grounds of referral if somebody wants to delay what might be an inevitable permanent loss of contact if serious grounds are established in respect of parental behaviour towards the child. So there is a balance, I think, there. Of course, as the Inner House has repeatedly said, Lady, the children's hearing is the body which makes the decisions about the welfare of the child, and the reason why the establishment or otherwise of grounds of referral was moved to the sheriff was to take that away from the children's hearing, leave them with the decisions that relate specifically to welfare, and keep the sheriff as the fact finder at proof. And it's the separation of those roles which is also an important safeguard within the system. And so there's definitely a balance to be struck. I wouldn't be able to agree that the structure is an incentive simply to accept the grounds.
But what about facts that may need to be found that aren't the grounds? I mean, how can you have a complete separation of fact-finding and evaluation of welfare?
There is a recent decision of the Inner House which looked at that very point, Milady. It's not directly relevant in this case.
But one could easily imagine that, particularly in a sibling contact situation, you could have one sibling saying one thing and another sibling saying another thing, and somebody would have to resolve the dispute of fact between them.
Yes. And in the recent case, which was before the Inner House of M against SCRA, and I have copies, and I can make more copies available for the court and for parties. But this was an appeal which arose in respect of something that the child said after grounds had been established. So grounds were established in that case related to the sexual abuse of the subject child by the father. And after grounds were established, the child reported and said things to her foster carer and to her social worker which were interpreted as suggesting that the mother may have been present during the abuse of the child. Those statements were referred to in the social work department's report to the children's hearing, and to some degree the children's hearing included them in the decisions in making a compulsory supervision order. And the Inner House looked at whether the children's hearing were entitled to take that information into account when they're not a fact-finding body and it wasn't part of the grounds. And the Inner House said, of course they are. They must take into account information which is provided after grounds of referral are established, in addition to grounds of referral, those matters being matters which relate to the welfare of the child. And it's about the children's hearing then hearing from other parties, making sure that the relevant persons have an opportunity to respond. And so in those circumstances, the children's hearing is relying on what might be called disputed facts, but they're taking into account everybody's representations.
So the grounds of referral is really a jurisdiction issue for the children's hearing. But once you get to the children's hearing, there's an evaluative task to be performed by the members, and that can include assessing disputed fact.
It can. And of course, it's always open to the reporter if something completely new arises in respect of that child to propose new grounds of referral. But the children's hearing, by reason of the decision in M against SCRA, is not prevented from carrying out the evaluative exercise that your lordship envisages.
Thank you.
I suppose that the fundamental principle of the best interest of the child infuses the consideration by the hearing, does it?
The fundamental test, I'm sorry, my lord.
Of the best interests of the child.
Indeed, that's the overarching the requirement of the children's hearing and making decisions about what should go in a CSO is about the welfare of the child as the paramount consideration.
So if it appeared to the children's hearing that the views of a sibling would contribute to an informed decision as to where the best interest of the child lay, would it be open to them to decree that the sibling should be heard?
It would be open to them to do a number of things. It would be open to them to ask for a report from the implementation authority specifically on that matter. It would be open to them under Section 78 to invite the sibling to come along and contribute their view to the hearing. I say that's not enough because the sibling is then contributing an uninformed view to the hearing. The sibling doesn't know what the social work department's recommendation is. They don't know what other papers are before the children's hearing. All they are doing is giving a view, and that's not taking part in the decision-making process.
Well, I suppose it depends on what is conceived to be necessary in order to get a properly informed contribution from the sibling. Surely it would be open to the court dealing with the matter to make sure that the sibling was properly informed about the proceedings so that an effective contribution could be had from her or him.
Well, the difficulty with that, my lord, is that particularly in relation to the provision of papers, the papers before a children's hearing are confidential to the children's hearing, the child and the relevant persons. My learned friend, Mr. Moynihan, for the principal reporter, in his case sets out the possibility of using one of the provisions of the rules, Rule 61, to enable the children's hearing to decide that they will give some of the papers to a sibling. It's, I think, probably best described as a theoretical possibility. I've never come across it. Those instructing me have never come across it. It might be certainly, it's not a provision which looks to be designed for that. Well, I perhaps will come on to that.
Yes. But
I'll make sure that copies of the Inner House decision are made available because it's perhaps an error that it wasn't included. It contains quite a lot of information about the structure of the children's hearing, so it may be of assistance. And I'll also provide the court with copies of Section 30 of the 2011 Act, which is not in the bundles.
It is actually.
It is?
It's in the Safeguarders bundle in XY.
I understand it's in the Safeguarders bundle in XY, and I'm sorry, I don't have access to it all. Tab 1 of the Safeguarders bundle. I'm grateful to my learned friends, provides Section 30, which is that a children's hearing must consider whether to appoint a person to safeguard the interests of the child to whom the children's hearing relates.
I'm not sure that we've got the Safeguarders bundle electronically.
What's the title of the Safeguarders bundle?
I'm sorry, I don't have it.
You won't know, but I'm just looking at what we seem to have. We've got, for XY, we've got a core volume, we've got the 6th respondent, the 5th respondent, and a very short statement of case from XL, and that's a volume of authorities.
Yes, for
Yes,
the sixth
yes,
responders. Tab 1 is the
yes.
relevant section.
That's right, absolutely. No, I've got it physically.
Physically, but
I
not
was asking for
electronically.
it electronically.
Right.
Oh, it's at MS 273 in the Safeguarders pen drive.
Well, I don't think it's been loaded on. Sorry, it's not your fault. It's nothing to do with you. But obviously, we are interested in trying to find the material, and some of us prefer it electronically to in heavy copy.
Some of us deal with it exclusively electronically. That's why it's very necessary for parties in cases like this to make sure that they assimilate the bundles and preferably combine them in a single bundle so that we're not leaping about all over the place.
One of the difficulties here is the confidential information between the two cases, and we did attempt. The joint list of authorities is a joint one.
Yes.
But the numbering has gone awry because we weren't able to assimilate the appendices. The joint bundle was prior to the instruction of Mr. Setright and to the bundle which is now produced for...
Oh, no, it's the last thing that arrived, and there probably is a pen drive that arrived with it. But, of course, I assumed it had been loaded up and it hadn't. So, never mind. We will press on. Let us not take up more of your time trying to sort things out.
Provision of the 2011 Act that requires the Children's Hearing to consider whether to appoint a person as a safeguarder. The Children's Hearing may appoint a safeguarder at any time when the Children's Hearing is still deciding matters in relation to the child. They must record the appointment. They must record the reasons that they made the appointment.
Take your word for it.
We do have it in electronic form.
XY 6th respondent.
273.
273.
Oh, it's the 6th respondent, is it?
Yes, that's what it is. Thank you.
Okay. Jolly good.
The assiduous Lord Hodge has come to the rescue.
There it is. Magic. Thank you.
For ABC, it was and is accepted that the status of relevant person isn't required for a sibling like him. It's accepted that he shouldn't have all of the obligations and all of the rights of a relevant person. He shouldn't have the obligations and rights in relation to acceptance or denial of grounds of referral. That's the grounds of referral usually relate either to very specific behaviour on the part of the child or very specific behaviour on the part of the adults. And so from that point of view, he doesn't need to accept or deny those grounds of referral and may indeed have no knowledge whatsoever of the behaviour which is contained therein. It's not every sibling who will want to have an involvement in the decision making. So ABC accepts that he shouldn't have a duty to attend a children's hearing, and the criminal sanctions shouldn't apply if he doesn't attend a children's hearing. I make clear it's also accepted by ABC that there will be some papers of a confidential nature to the subject child to which it would not be appropriate for him to have access. Might not be appropriate for him to have access to, for example, very specific health information about his sibling. And the latter, that last one, is provided for in the statutory scheme because Section 178 of the 2011 Act allows the Children's Hearing to make what's called a non-disclosure order in respect of certain papers. The court will find that at MS 0805. And the rules relating to how the Children's Hearing comes to that determination, the court will find it MS 0891 onwards. It's a non-disclosure request, which leads to a non-disclosure order. Of course, in this particular case, ABC, when he was subject to CSO himself, had all the papers that related to the reasons why A, B, C and D, E, F were accommodated. But accepting as I do that a sibling shouldn't have the ability to deny or accept grounds of referral, shouldn't have the duty to attend, why then are we here? And the answer to that is because of this binary all or nothing bright line distinction, because I can't get the things that are minimum requirements for me to have a proper opportunity within the structure. It's only the structure that forces people down the road of trying to become relevant persons to enable them to get that proper opportunity.
Well, I'd welcome at some stage a clear guidance. You're telling us what the sibling doesn't need. What do you say the sibling does need in order to give effect to the Article 8 rights?
And that is the very next paragraph in my notes.
Thank you very much.
Because I think you've indicated to us what duties should not be imposed on the sibling. The real issue is what rights the sibling should have access to.
Indeed.
And that's what you're coming to.
Yes. What then was required for ABC at the two hearings, and what is required to make this system compatible. And I have a list of minimum requirements. The first of those is a very practical one. It's notification of a children's hearing which may make a compulsory supervision order or an interim compulsory supervision order. And in answer to a question, well, why do you need that? Well, it's a basic requirement. If you don't know that a children's hearing is going to take place, you have no opportunity to take part in it. You need to know that it's going to happen because it is those kinds of children's hearings which make the important decisions in the sibling relationship. It makes the decision about where the child is going to live. As the court's seen in V against locality reporter, the siblings in that case were accommodated in separate placements. In this case, A, B, C and D, E, F are in separate placements. If the children's hearing is going to make an order which might separate siblings, then notification is required. And it's those hearings which might also make orders in relation to contact between the siblings. So notification that it's going to take place is the first minimum requirement. The second minimum requirement is the provision of papers that are going to be considered by the children's hearing. We go all the way back to McMichael, which I'm not going to take the court to, but McMichael stresses the importance of the availability of the papers to parties before the children's hearing, before decisions are made. And the absence of provision of papers to Mrs. McMichael was a violation of her Article 8 rights. That provision of papers is already subject to Section 178 and the provision that I've given to the court that some papers can be the subject of a non-disclosure order. Can I pause here? The provision of papers in the case for the Lord Advocate, there's reference to papers being confidential to the core family unit. Can I say to the court that there's no distinction between siblings in a core family unit? In ABC's case, his core family unit is his mum, his dad, his two siblings, his two sisters and his brother. They are one core family unit. There does not exist in families 3 or 4 core family units, depending which child you're talking about. In my own family, there are 3 siblings. I exist in the same core family unit as my 2 brothers. So if papers are confidential to the core family unit in DEF's case, then they are also confidential to ABC.
I think your comment may answer a question that was going through my mind. When you say your client should have, and we've got 1, 2, we're coming on to 3, my question was, are you saying that all siblings who have established family life within the meaning of Article 8 should have 1, 2, 3, 4, how many you've got?
If they want to be involved. So the first step's notification. If they then don't respond to that notification and don't seek an opportunity to take part in the decision-making process, then there's no need to go down the remaining number of steps. But you have to do the notification to establish whether they do want to be involved in that decision-making process.
How does that work in relation to a 3-year-old sibling who has established family life with the subject child?
Well, in those circumstances, I can see that there might need to be a requirement that it would have the same presumption that we have across a number of statutes in Scotland, that a child of age 12 has sufficient age and maturity to form their own views and to provide their views to the children's hearing. A child of 3 is clearly a child who's not going to be able to form necessarily a view that they might come along to a children's hearing and form akin to a legal submission. But they may well have views, and notification could be through the social work department. It could be, if the child is slightly older but at primary school, through their education provision. But it's the notification and then to see whether the child then wants to become involved that is the crucial step.
This would be every children's hearing, or just the first?
Every children's hearing.
Can I just be clear? If the notification requirement is satisfied and the sibling expresses an interest in participating, are you saying that because of her or his membership of the core family unit, she or he is entitled to access to all of the papers that have been generated? Because I'm just wondering whether there might not be circumstances in which it would not be in the best interest of the subject child for every document to be released to her or his sibling.
And Section 178 already provides for that.
I see.
I'm not suggesting that they have to have every single document and that Section 178 shouldn't be applied. Section 178 provides for a non-disclosure request to be made and for an order to be issued, which would prevent that.
Sorry, forgive my ignorance.
Yeah, but that's not a best interests test. The non-disclosure arises if it is likely to cause serious harm to the child.
Significant harm.
Significant
I
harm
apologise,
to the
significant
subject
harm.
child, yes.
Yes. So it's not a straightforward best interests test. You have to get to a higher hurdle before you can fail to disclose.
Yes. The third minimum requirement is a right to attend such a children's hearing. That's going to be a children's hearing that may interfere with the sibling relationship, or put another way, interfere with the siblings' Article 8 rights. The fourth minimum requirement is a right to make representations to that children's hearing. The fifth is a right of appeal or review. And the importance of that as a safeguard is emphasised by the case we looked at of V against locality reporter. It doesn't have to be an appeal at which evidence is heard. It has to be the right to have that decision appealed or reviewed. The structure is that appeals are made to the sheriff in the children's hearing system. And the sixth and final minimum requirement is a right to request a children's hearing to review the direction which is made as between siblings.
Is that the an annual review rather than an appeal type review?
Well, Lord, the CSO has to be reviewed every 12 months at
Yes.
least.
In any event, yes.
Relevant persons can ask for a children's hearing to be arranged to review after
Oh, yeah.
3 months.
After 3 months.
And the qualification of the 3 months is perfectly acceptable for a sibling, but there are circumstances, and one can readily envisage them, if there's contact fixed to take place at a specific place that maybe doesn't become suitable, or the child one of the children is too old for that play provision, for example, then you might come back and seek to review it.
Would you include in that a review of a direction as to placement, which, for example, placing siblings in separate placements?
I would include that. It's not relevant in ABC's case.
I know that, but we're talking generally
In
here.
general terms, yes, I would. What could be more important to the sibling relationship than being able to contribute to the decision-making as to whether or not you're going to be placed together? In the vast majority of cases, it will be better for children to be placed together. I accept there are resource implications for that. There will be rare occasions where it might be better for these children to be placed apart if they're going to be re-traumatised, if they've been subject to abuse, etc. But those will be rare. So the ability to seek review of placement apart is, I think, essential if one broadens it out from ABC.
Well, that's why I was asking you. It may not be generally understood by the English members of the panel that the children's hearings directions are usually much more specific in relation to placement, aren't they? Unless they've changed, or have they now changed?
They are very specific.
Yes, they say where somebody is to be placed.
They
Yes.
specify the name
Yes.
and address of the foster carers, which might be subject to a non-disclosure
Yes.
order so that it's
Yes.
not revealed to everybody else, but the actual CSO, which is maintained by the reporter, is very specific.
Yes, yes, but a care order made in the family court in England and Wales cannot do that,
I
and
see.
does not do that.
I did not know that.
Well, we can all share information about.
Now, I say those minimum requirements were not and are not provided for in the statutory structure, and there's no way, I say, to read the statutory structure in a way to provide those minimum requirements. Certainly, ABC was not afforded those minimum requirements at either of the children's hearings that are complained of. Now, the principal reporter maintains that the 2011 Act, together with the rules of procedure, as he says, sensibly operated, could afford ABC a proper opportunity to take part without him being a relevant person. Now, I don't agree with that proposition, but even if the court does, The Act and the rules certainly weren't sensibly operated at the children's hearing on the 7th of September and the 5th of December. For the 7th of September hearing, ABC wasn't notified of it at all. He, to give the court an indication of geography, his school is right next to the Children's Hearing Centre. He knew that his mum and dad were at the Children's Hearing Centre when he finished school. He went to go and meet them there. He was allowed in by reason of him turning up to the children's hearing. He was allowed in for a few minutes and then asked to leave. He wasn't given any indication as to what was in the reports. He wasn't told what the decision was. He wasn't told after the children's hearing what the decision was, other than by his parents. He didn't have a right to appeal the decision. He tried. An appeal was lodged at the Sheriff Court, but ultimately, on advice being taken, the appeal was agreed to be dismissed. On the 5th of December, he was notified, but not in terms of Rule 22 or Rule 81 of the rules. He was notified after those instructing me, his then solicitors, wrote to the principal reporter. If I could take the court to that. Productions Code Volume 2, tab 6. At MS 0445, there is a letter dated the 3rd of November 2017 from Clan Child Law to the reporter. It's at tab 6 in the second core bundle. It is again redacted. And they say, we confirm that we act for, that should be ABC, older brother of DEF. We understand that a hearing is taking place in relation to DEF on the above date in order to discuss and make a decision on the supervision of contact between DEF and his siblings, including ABC. We are aware that the forthcoming children's hearing has been arranged following upon a children's hearing held on 7 September 2017, where decisions made were not recorded on the compulsory supervision order. We do not consider Section 81 of the Children's Hearings Scotland Act 2011 to be the appropriate procedure for ABC. However, there is a clear need for ABC's rights to be protected before a decision is made which will interfere with those rights. Please advise us of how the Principal Reporter intends to ensure that ABC's rights are protected in relation to the forthcoming children's hearing in order that we may advise ABC accordingly. Now, in response to that, the Principal Reporter, or on behalf of the Principal Reporter, response was written. It's MS 449, tab 7 in that bundle, dated the 9th of November. And the reporter writes, your client ABC, further to your letter of 3rd November, whilst I believe that the participation of, and that is ABC and DEF's parents, and their representatives at DEF's hearing will be sufficient to ensure that ABC's rights and interests are protected. On this occasion, I will invite ABC to the hearing, as it appears that he can contribute to the consideration of DEF's case. However, it will be for the panel chair at the hearing to decide whether and for how long ABC should attend. It would be very helpful if ABC could provide any written information he wishes to be considered by DEF's hearing in advance of 5th December. That was the notification that he received, and I accept that would meet my first minimum requirement for the hearing of the 5th of December, because I knew it was going to happen. But on the 5th of December, no papers were provided. And as I've indicated, the lay panel get the papers in advance. The rules provide that that's preferably 7 days in advance, but no less than 3 days in advance. The child and the relevant persons are also required to have the papers no less than 3 days in advance. It will include the reports that I've indicated, and very importantly, the report of the Implementation Authority, that's the Social Work Department, and their recommendations as to whether a CSO should be made or continued and what it should contain. In practice, if the papers aren't distributed in advance, the children's hearing will be continued. And the reason for that is to make sure that those making representations and those making the decisions have time to consider the papers before them. ABC didn't get the papers at either of the children's hearings complained of.
He was represented by a solicitor.
He was.
On the 5th of December.
Who also didn't have access to the papers.
My question was legal aid obtained for that?
There is no legal aid there's a system whereby legal aid can be provided for legal representatives for relevant persons and for the child. It's called the ABVOR hearings, where you're not a relevant person or the child, then there's very limited opportunity to obtain legal aid for attendance. In the particular instance, in this case, Clan Child Law did ask for legal aid for the 5th of December and were refused. Clan Child Law is a charity, and representation was then provided pro bono.
Thank you.
To enable him to have representation. And I do understand that there are solicitors who do provide that representation pro bono because of the difficulties with legal aid.
Thank you.
It's perhaps a good point to go to Rule 61, which is the rule which the Principal Reporter now suggests may be used to allow hearings to be continued and papers provided to persons who are not relevant persons. The suggestion is that Rule 61 be used for that purpose. That's at MS 0869 on the memory stick. It's in Volume 1 of 4 of the Authorities at page 138 in tab 4. And the particular reliance of the Principal Reporter is on Rule 61(1)G, which is where the children's hearing proceeds, and that includes a hearing where they're going to consider a CSO. The children's hearing may, and G provides, give any other direction on any other matter as is necessary to enable the hearing to make a decision on whether to make a compulsory supervision order, and if so, the measures to be included in that order. And if I understand the Principal Reporter's position correctly, it is that the children's hearing direction would be that certain papers had to be provided to the sibling to enable the children's hearing to make a decision, and for that reason the hearing would be continued while that happened. As I've indicated, maybe that provision could be used for that purpose. It's certainly never been used, to my knowledge, for that purpose. but it certainly wasn't used to provide ABC with papers on either the 7th of September or the 5th of December. ABC had no right to attend the 5th of December hearing, as I've taken the court to. The notification told him he could come along, and it was at the discretion of the chair as to whether he would be allowed in. He was allowed in. His legal representative was allowed in, but that was at the discretion of the chair of that children's hearing. He didn't have the right to make representations. He was asked to submit written representations in advance. Now, he did do that, and the written representations are in the core volume 2 of 2. The second part of the core volume is tab 8 for those on paper, and it's MS 0453.
Sorry, 453.
453.
Okay.
He did so through his solicitor, and he did that on the 27th of November, and the court will see that the submission, the written representation is, thank you for your letter of 9th November, having taken instructions from our client ABC in relation to contact with his brother DEF. ABC would like to see his brother frequently and would like contact not to be supervised. ABC does not know what the recommendation is from social work and would like to be involved in the children's hearing so that he can respond and address panel members once he has this information. I'd be grateful if the letter could form part of the papers for the hearing. Now, in the first instance, the request for written representations when you don't know what you're responding to is not an opportunity to take part in decision making. The rules require that a children's hearing chairperson summarise the content of reports. The implementation and GIRFIC implementation reports about this thick in an ordinary case, and the ability of the chairperson to summarise that will of course be subject to that person's abilities. But what happened on the 5th of December was that there was a very brief summary of what might have been contained in the papers, and ABC through his solicitors amplified those written representations by saying that he wanted to see his brother frequently and that he didn't want that to be supervised by somebody from the social work department. He didn't have the right to make representations. But he was able to do so through his solicitors at the children's hearing. He did not have a right of appeal or review of that decision. He presented this judicial review as his only option. In this judicial review, the substantive hearing took place 4 months after the first orders were made in December of 2017. The decision was issued 8 months after the first orders were granted. An appeal to the sheriff has to be marked within 21 days if you're a relevant person. And then there are timescales which are provided for the hearing of that appeal. They are adhered to more in the exception than they are in the rule. But there is still a time pressure because these are, of course, decisions relating to children who keep growing up while the courts are debating it. And of course, if you go right back to the beginning, if you haven't been notified about this children's hearing taking place at all, then your ability to judicially review a decision that you don't know has been taken is impossible. And ABC continues to have no right to request a review children's hearing to look at the direction which is made as to contact between DEF and him. If one looks at it, that the 7th of September 2017, he wasn't notified of anything. I mean, there's no opportunity to take part in that decision making at all. And on the 5th of December, it is extremely limited. And in those circumstances, the decisions were unlawful. But even if sensibly operated in the future, those informal measures that took place on the 5th of December, as I say, don't constitute a proper opportunity to take part. I know that the principal reporter relies on a practice direction change that notifications will be sent to siblings. That continues not to be the case. There's been a further judicial review lodged in another case by those instructing me and intimated either at the end of last week or at the beginning of this week. The problem still occurs. The principal reporter also relies now on section 126 of the 2011 Act as being a possible mechanism whereby a person in ABC's shoes could have that proper opportunity to take part in the decision making. Section 126 of the 2011 Act is at MS 787, and it is a provision, in my view, it's a very strange provision in the 2011 Act. First of all, it only applies when a contact direction is made. Immediately, the vast majority of siblings who are before the children's hearing are excluded, because in the vast majority of cases, the CSOs don't include any specific contact direction in relation to sibling contact. And woefully, that is especially where both of the siblings are accommodated but separately. It's usually left to the discretion of the social work department or direct cooperation between foster carers. There is in the court's papers at MS 0527 and the following pages some examples of where orders have been made and where orders haven't been made, just to inform the court. They're not, there are cases in which those instructing me have been involved. So if there's no contact direction, section 126 doesn't apply at all. So if you're a sibling who wants to see their brother or sister who's the subject of a CSO and the children's hearing don't make a direction, then section 126 is useless. Second of all, it provides a kind of after-the-fact review. The decision has already been made by the children's hearing, constituted to look at the CSO and what it contains. This section 126 provision is something which comes along after the decision has been made. And it comes along afterwards solely related to contact. No other matters are covered by section 126. So, for example, placement together or apart, there's no resolution for the sibling found in section 126. The compulsator on the reporter to arrange a section 126 hearing only comes if there's a court order in place in relation to contact between the child and an individual, or if a permanence order is in force and that contains arrangements for contact between the child and an individual. Siblings are unlikely to go to court and ask for a court order to see their brother or sister. So that is unlikely they'll be involved there. Permanence orders, again, unlikely. So, but in those two circumstances, the principal reporter must arrange a children's hearing. If this section 126 is to be interpreted in a way which would give a sibling an ability to have an opportunity, then they have to request that the principal reporter arrange a children's hearing. And they can only do that if they fall within the definition of person in the 2013 order. The court will find the 2013 order at MS 813, but you might not want to look it up because it's just in exactly the same terms as section 81. It is that a person who has or recently has had a significant involvement in the upbringing of the child can request a section 126 hearing if a contact direction has been made.
So just to make sure I understand it, you're referring to 126(2)(b), I think, that's the
Yes.
request. And the individual in question has to be specified by an order made by the Scottish Ministers, which you say is the 2013 order.
It is.
Which has the same constraints as Section 81.
It does.
Thank you.
Now we've got the same notification problems as we do across the Act as a sibling, because you have to know that a decision's been made to know that you might want to ask for a hearing to take place. The principal reporter is not required to give that notification to a sibling. They are required, the reporter is required rather, to consider whether anybody looks as though they have had significant involvement in the upbringing of the child, and tell that person that a hearing is going to take place. You're not allowed to come, but the hearing might decide to make a contact direction. And if it does, you'll be able to ask for a hearing to be arranged under section 126. Now, the problem is that the reporter has to arrange that hearing to take place no more than 5 working days after the original children's hearing. And the reporter is required to send out the invitations and the notifications for that no more than 3 days after the children's hearing that took place. So there is a very small window in which a sibling who might not be told what the decision is has to decide whether to request a section 126 hearing. The limitations of the rules, those rules are Rule 81 and Rule 42. Rule 81 is at MS 0888. And Rule 42 is at MS 849. The court will find nothing in the rules about giving information within that 3-day window as to the direction that was made or the reasons for it, because the direction and the reasons for making it are only sent with the notification that a 126 hearing is going to take place. So in this scenario, ABC is told that a hearing might take place, a hearing is going to take place, it might make a contact direction, you might be told that it has, You won't be provided with the contact direction or the reasons for it, but you need to decide whether you want to request that a 126 hearing is held within 3 days of the children's hearing. Only then will you be provided with the direction, and only then will you be provided with an excerpt of the reasons that the children's hearing made the decision. And overarching all of this is that no such notification was sent to ABC for the 7th of September 17 or the 5th of December 17. No Section 126 hearing was arranged after either of those children's hearings. And so in relying on Section 126, I can only assume that the principal reporter argues that this is a reason the legislation is not incompatible.
There's a dichotomy here, isn't there, between the proper operation, or perhaps I might say the enlightened operation of the statute and its shortcomings that would give rise to a declaration of incompatibility.
No, because the Section 126, however
enlightened,
operated,
yeah,
can't give you that proper opportunity to take part. It falls down in a number of respects. If a Section 126 children's hearing is arranged, then the people who are the sibling or the person who's got the contact order is given the direction that was made by the children's hearing in the CSO and the reasons for that contact direction, and then excerpts of reports which are relevant to that. Now, again, in the case which I have, M against the Scottish Children's Reporters Administration, which I will make sure there are sufficient copies for everyone tomorrow, the Inner House in that reiterated what it has repeatedly said, is that decisions of the children's hearing have to be read as a whole. So there are decisions which flow from each other, and getting a very narrow excerpt of a report is not going to give someone the information that the children's hearing had when they made the decision. And the other reason, to answer your Lordship's point, is Section 126 only kicks in if a direction's made.
yes.
So if there's no direction at all, it doesn't give a sibling that opportunity to ask or contribute to the decision making. And if ABC were to request a hearing, even though he doesn't consider he falls within the definition in the 2013 order, and a hearing was arranged, and he turns up, if that children's hearing don't consider that he falls within the definition, then the hearing just stops, and there is no right of appeal from that.
Ms. Brabender, don't so many of your submissions this afternoon militate in favour of a bespoke consideration by the chair of the meeting in relation to the points that you have made? You've made certain, 6 general requirements, but you've only got to go through them to see that they may or may not be apt in the case of a sibling who has achieved a family life. And so, should this sibling be notified of the hearing? Should this sibling be provided with any of the papers, and if so, which? Should this sibling have the right to attend? Should this sibling have a right to make representations? How can any blanket arrangement be suitable? Surely it's for the chair of the meeting to be required of the hearing to be required to consider at some early stage these points, sibling by sibling.
To take that in turn, the first minimum requirement of notification occurs before the chair of the children's hearing can even consider matters. So notification has to be blanket, as your lordship puts it, to achieve reaching the siblings who require notification that this might occur. I can see that if there is blanket notification, even to those who the principal reporter considers to have established family life, then I can see that the chairperson would then be able to make bespoke decisions depending on the age of the sibling, the level of maturity of the sibling, what it is that the sibling wants in terms of contribution. And I can see that. And if the structure of the Act allowed for that, then that might be the way forward. But again, going back to we all make mistakes and human feeling will always come in, under the current regime, even if the chairperson used all the tools that are available to them to create this bespoke system, there is no right of review or appeal. And there is no ability to then ask for a children's hearing to be held subsequently to look at this issue again.
Thank you.
Whatever is the answer, and I say the answer is legislation, because this legislation is incompatible. But Section 126 isn't the way forward, because that disallows the bespoke system that your lordship imagines, because it's so rigid and it's an after-the-fact review. I'm conscious of time. The court does have my full case in the papers. I think I ought to address, I think I have addressed it in relation to these decisions and my submission that the decisions of the 7th of September and the 5th of December were unlawful. But separate from that issue is, of course, the questions in the statement of facts and issues in ABC as to whether the provisions of the 2011 Act and indeed the associated rules can provide, even if they didn't, can provide ABC with a proper opportunity to take part in the decision-making process. Now, having looked through those informal measures, the discretionary measures that are available to the chair, to Section 126, I say that Section 200, in defining a relevant person and creating the bright line all or nothing system, and Section 81, in limiting the persons who can apply to be deemed relevant persons, both of those sections are incompatible with ECHR. Whether Section 126 provides a proper opportunity for a person with a contact order or a right under a permanence order to take part in decision-making is not before the courts, but it certainly doesn't provide that proper opportunity for anyone else. When it comes to then, can the provisions be read in such a way as to be compatible? Well, we can see through my answer to your lordship's question that notification would require to be inserted into the rules, so notification so that someone knows that a children's hearing is going to take place. And to some extent, there are provisions, if you use the principal reporter's now creative thinking in terms of Rule 61.1G, but where ultimately we always fall down is that there is no right of appeal.
So that's, to use a current phrase, the backstop.
I hesitate to enter into a backstop conversation, but I say there's a firing gun and a backstop, which are both crucial. There's a notification that would have to be mandatory, and then there's a right of appeal to recognise the safeguard that's required in case it goes wrong.
The chair of the children's hearing could fire the gun, though. She or he could notify a sibling if required. Is that right?
They could, if the gun hasn't been fired before the chair is sitting in the children's hearing, then they would have to continue that children's hearing to allow the gun to be fired.
Continue means adjourning.
Adjourning,
Yeah.
adjourn
It
and
means not
refix.
continue. doesn't it?
Yes, it means not continue, yes.
Mrs. Scott is in a better position to understand that difference between England and Scotland, but yes, adjourn and refix.
Yeah.
Yeah.
They would have to, and
Yes,
that would have to be a mandatory direction to every chair of every children's hearing, that if at the start you discover that a sibling hasn't been notified,
Well, I
then
just
you
wonder whether
have
it needs to be a
adjourn.
mandatory direction. I mean, if the overarching principle is the best interest of the child, and it's perceived by the chair that a contribution from a sibling is required in order to ensure that the best interests of the child are properly catered for, I mean, does it need a mandatory direction to every chair that they should consider whether or not to involve a sibling?
In my view, without a mandatory notification, then
It's not going to happen.
it won't happen.
Yeah.
And so there are two component parts that I say just cannot be read into this legislation. That's the number one, the notification, and it's number 5, the right of appeal.
Yes.
And with that, the inevitable conclusion is that the 2011 Act and its associated rules cannot be read in a way which would give ABC and persons in his shoes, those who have established family life, those who have the procedural protections of Article 8, and where the children's hearing might interfere with that right to family life. The legislation can't be read in a way which gives those people, ABC included, a proper opportunity to take part in the decision making. And in those circumstances, a declaration of incompatibility ought to be made in respect of those provisions. And unless there are any other questions, that would conclude the submissions for ABC. I will make sure the court is provided with the copies of the decision of the Inner House. My learned junior has notes of any other matters which are required to bring tomorrow morning, and we'll make sure that those are before the court before the hearing starts. And there is some little time in the timetable that we've all agreed for a response on behalf of ABC after the multitude have spoken.
Well, as far as I can see, there are no more questions to be thrown at you, Mrs. Brabender, and you've timed it brilliantly, if I may say so. I don't think we'll mind having an extra 4 minutes at the end of the day. I mean, so we won't get anybody else on their feet now. That would not be sensible, unless your learned junior wishes to follow. Well, thank you. The court will now adjourn.